At 10:03 a.m. Eastern Time this morning, the United States Supreme Court issued a devastatingly brief order that effectively slammed shut the final legal escape hatch in this historic case. 2 words, 1 sentence, no dissent, application denied, 9 justices, absolute unanimity, no written opinion, no legal analysis, no explanatory footnote, just a stark judicial full stop that ended months of procedural maneuvering in an instant. What makes this moment extraordinary is not only the ruling itself, but its timing. The court's decision came exactly 72 hours after Melania Trump's legal team submitted a formal proffer agreement to federal prosecutors, outlining the evidence she is prepared to provide in exchange for consideration of immunity. 2 seismic legal developments, separated by precisely 3 days. That alignment is not coincidence. It is coordination. Before anyone dismisses this as gossip or cable news exaggeration, let's be precise. This story is grounded entirely in verifiable public records, court filings, a proffer agreement, an official Supreme Court order, no anonymous whispers, no unnamed insiders. These are documents anyone can review. Here is what is now legally settled. Melania Trump has voluntarily waived spousal privilege, the legal shield that ordinarily prevents prosecutors from compelling testimony between spouses. She was not forced. She chose to waive it. And the evidence she is offering falls into 3 decisive categories. Financial records demonstrating her awareness of disputed asset valuations, communications, including messages and conversations about property values and loan applications, direct testimony, corroborating sworn statements already provided by accountants, bankers, and appraisers to the grand jury. With the Supreme Court's rejection now final, there are no appeals left. No procedural pauses, no further delay tactics. The grand jury is free to hear her testimony, potentially within days. Remarkably, her former husband's confirmation hearing for a cabinet-level position is scheduled for early March, just 6 weeks from today. To understand how deliberate this moment was, we need to walk through the exact 72-hour timeline, because this did not unfold spontaneously. Monday, 2 p.m. Eastern. Melania Trump's attorney submits a proffer agreement to the special counsel's office. In plain terms, a proffer is a preview. This is what I know. This is what I can prove. This is the evidence I'm prepared to testify about. Prosecutors then decide whether immunity is warranted. Proffers are common in federal cases. What is not common is who is proffering and what is being offered. Tuesday, 2 p.m. Eastern, hour 24. Exactly 1 day later, the defense files an emergency appeal with the Supreme Court, asking the justices to block her testimony before the grand jury can hear it. The argument, spousal testimony violates marital privacy under the Fifth Amendment. Emergency appeals usually take weeks to prepare. This one appeared in 24 hours, strong evidence the defense anticipated this move. Wednesday, hour 48. The Supreme Court formally dockets the appeal, but crucially, it does not issue a stay. That silence matters. When the court believes an argument has merit, it pauses proceedings. When it does not, the process continues. Thursday, 10:03 a.m., hour 72. The ruling arrives. 1 sentence. No dissents, not even from Trump-appointed justices. That level of rejection is rare. In decades of tracking Supreme Court litigation, I've seen it only a handful of times. Each time, it meant the legal argument wasn't just weak, it was unworthy of discussion. Now let's look at what's inside the proffer, because the substance matters far more than the headlines. First, financial documentation. She signed joint tax returns from 2014 through 2020, 6 years of filings submitted under penalty of perjury. Those returns relied on asset valuations. If values were inflated to obtain loans and deflated to reduce tax liability, that pattern supports both bank fraud and tax fraud exposure. The proffer indicates she attended meetings with accountants, asked questions, and received explanations, evidence supported by emails now in prosecutors' possession. Second, communications, text messages, emails, and recorded phone calls discussing property values ahead of lender meetings. In federal cases, recordings are admitted only after rigorous verification. If they're included in a proffer, prosecutors have already authenticated them. Third, corroboration. Her testimony aligns with sworn statements already given by accountants, bankers, and appraisers. In federal prosecutions, corroboration is everything: multiple witnesses, same meetings, same facts, documents to match. That combination is extraordinarily difficult for any defense to overcome. The true legal earthquake lies here. She waived spousal privilege voluntarily. Supreme Court precedent, most notably Trammell v. United States, 1980, establishes that spousal privilege belongs to the witness, not the defendant. If the witness chooses to testify, the defendant cannot stop it. That law has never been overturned. The defense's emergency appeal failed because voluntary waiver is settled law. There was no coercion. Her attorney initiated contact. No subpoena was issued, no threats made. The court does not create special exceptions based on status. Emergency appeals require two things: irreparable harm and a likelihood of success. This appeal showed neither. So what happens now? The grand jury, meeting Tuesdays and Thursdays, can hear her testimony within days. Once that happens, prosecutors face a strategic choice. Option 1, use her testimony to strengthen existing charges. Option 2, seek a superseding indictment with new charges, potentially including conspiracy, based on newly corroborated evidence. With trial scheduled for September 16th and no delay tactics remaining, the timeline is now locked. Beyond this case, the implications are historic. Spousal cooperation at the highest level of power is now firmly established. Privilege claims can no longer be used to stall federal prosecutions. Status, wealth, and influence do not alter the law's application. Today, the court said no. The system held. The precedent is set. The next 30 days, grand jury activity, defense motions, and the final immunity agreement will reveal exactly where this case is headed. History didn't turn on a speech or a spectacle this morning. It turned on two quiet words issued from the highest court in the land. Application denied.